an authority on gender law. Thank you so much, ma'am, for being with us today. Ma'am, we would first, I will start with a personal experience. So I came across your name and your work when I was working on gender issues in AMU. So whenever I had to refer on any gender related law, it had to be your book. It was very exhaustive. Therefore, your name stayed with me. Then I saw you in the court during 𝗙𝗃𝗃𝗃𝗃 hearing. I was assisting Mr. 𝗙𝗲𝗃𝗀𝗀𝗃𝗀.
Oh, okay.
I couldn't take my eyes off you, ma'am. It was a packed courtroom. I couldn't talk to you, but I kept observing you. And the thought that stayed with me was, this woman has been through a lot. And I wanted to know what that lot would have been that made you what you are today. And so I Googled your name. I already knew that you had co-founded Majlis. You were leading it quite well. For those who don't know, Majlis has been in the area of women's rights and child's rights. They provide quality legal service to women and children since 1990s, though you have been, of course, in part of the women's movements in 1980s. So I Googled your name, and on Wikipedia page, I read about your personal life. So since then, it has been my, kind of a desire that at some point I'll talk to you and I'll make the world know what this woman has been through and what has actually led to the changes, because you're not somebody who projects herself a lot. You do a lot of work, ma'am, and it's not like people know about you through self-promotion. No, but through your real work. So we would really want to know what was your personal journey like, and right from the time of your marriage or before that, wherever you would want to begin from childhood to when you started Majlis, and all throughout, like 80s, and then the present criminal law amendment, everything, ma'am.
Thank you so much, Sanchita, for following me for so long. I didn't realize that during the 𝗙𝗃𝗃𝗃𝗃 arguments in court that there were people watching me and observing me. That's a pleasant surprise. There were a lot of people, young students, smiling at me, but I didn't know them, and I was very hesitant to go out of the way to say hi to them. But you're right. I have done different kinds of work, and mainly the issues that I have taken up, I've always written about it. So, and I've tried to give a different perspective than what is the mainstream perspective about it, because it comes from a very rooted experience of actually handling cases or actually experiencing the violence, etc. So that way, it is different, and it is very grounded, and it is very, there are a lot of finer nitty-gritties that I include in my writings, so that somebody understands, not just from a theoretical perspective, but from the ground level experience, and building theory from this experience onto the domain of legal knowledge. So when I joined the women's movement, I was just a housewife, homemaker, and people always wanted to know, why did I join? Why did I join? What is it that made me come into this movement? And I was there like wholeheartedly, and I was very excited about it. I was very happy to be there and meeting a lot of women who think like me, who are lawyers, who were highly educated, journalists, doctors. They were coming from various fields and belonging to a certain upper class milieu. But I did not feel out of place there, because the ideology, the understanding of marriage, of violence, of rape, etc., is something that I knew and I shared. So that was good. But when they asked me why did I come into the movement, actually I wrote my first um, essay, which was on those days cyclo-style paper. So I typed it on the cyclo-style sheet. Unfortunately, I had two advantages. What I lacked in education, I was fluent in English and I could type very well. So from my experience, I was able to bring out articles very fast, which people would take a long time to write. Because of my experience, the typing skill and the command over English at a very basic level. So in 1981, I wrote the cyclo-style essay called "Why I Joined the Forum." It was a group called Forum Against Rape, and there were weekly meetings there, and it was autonomous, and we used to meet there, and there was a rape similar to the Mathura rape that happened in the outskirts of Mumbai. And I said I would like to go for the investigation. And but I said I have no experience whatsoever. When I went there, I realized that nobody had any experience. And moreover, that girl and her family belonged to Karnataka, spoke Kannada language, which I also know, and because I also come from Karnataka. So in fact, I could communicate very well with the girl and her family and picked up a lot of nuances over there. And then when I came back, I would type out these reports and submit very methodically. I'd worked in an office before my marriage abroad. So I worked abroad before my marriage. So everybody was quite impressed with that. They said, oh, she's so systematic and she gives a very accurate report every time she goes. She brings out the lapses that had happened in the earlier investigation, etc. And people would think who is this person? She's got certain leadership qualities. Maybe she's coming from some leftist groups, etc. So when I wrote my piece and gave a description of the violence that was taking place in my life, and I didn't write it in my own name. I took a pseudonym because I didn't want people to identify me. But of course, everyone identified me. And then I was always pointed out that she's the one who gets beaten by her husband. So there were questions like, why doesn't she leave? And why does she stay in this marriage, etc. And there were very practical difficulties, like where would I stay? Where would I take my children? Where would they study? Where would the money come from? I'm talking about 1980. So when I wrote that, that was the very raw kind of writing. And before that, there were two issues that were concerned with the women's movement. One was rape and one was dowry debt. So there was nothing in between. These are extreme, dowry debt means somebody has been murdered, burned to death, etc. And that was domestic violence. Or there was rape, gang rape, police rape, rape by local gundas, all kinds of rape. And this kind of news used to appear in the papers. But I've told them there's a lot of violence that happens before somebody gets murdered. Murder is the ultimate. But when there's violence, there is abuse, there is verbal abuse, there is physical abuse, there is psychological abuse, there is sexual abuse, economic abuse. Abuse comes from in different forms. And women tolerate it. And here the group wanted to set up Mahila Atma Suraksha Sangh in that place, which is about 2 hours away from Mumbai. I said, why so far away are we setting something? We should set it up here. Because there are so many women who are abused, were assaulted, subjected to cruelty. So many rapes happen in the city of Mumbai itself. So the whole idea of writing my piece was to communicate to them the reality of women's lives. Because I felt that they did not have the reality of ordinary women's lives. That was the beginning of my writing. In 1984, it came out into that small publication, my story, our story of rebuilding broken lives. And that was at a seminar. By the time we had set up a women's center where women could come and share their experience, not like professional counseling or lawyers, but just to come and share their experience, what they are going through, or what are the resources they had found on the way, what are the legal strategies they were adopting, etc. So here was a conference that in 1984 November end, which where there are shelter homes run by traditional women's organizations, and they had a particular way of addressing victims of domestic violence, like those women are like this, those women are like that, you should never trust those women. And I say, excuse me, all of us can be those women, and why are we putting this into categories like this? So at that meeting, the first version came out, and it was available for 10 rupees. But it created such an impact on everybody that, oh my God, we did not know like this is domestic violence, or this is the way it takes place. So that was the first version. And after that, there was a long way that we went. After that, in 1991, we set up Majlis. By the time I had become a graduate, I had done my law, and I had moved quite far into rebuilding my life. And learning law was very important, because all the time we could discuss strategies, but to go to court, you needed a lawyer. And that was my purpose of doing my law, so that you are able to help women practically. And you don't have, like what you call feminist legal strategies. How do we help this woman? Not in the conventional way of what lawyers think, but trying to find out innovative ways in which we could help out and reach out to women. So in 1991, women's Majlis started. We were very clear. I was very clear that what we are offering is professional legal counseling and support of various kinds. So that, so 1991, very hesitantly set up Majlis. It went through a lot of ups and downs. Of course, in 1992, Babri Masjid got demolished. The name Majlis was linked to Muslim fundamentalists. So it was very difficult to get any permission, to get a place, though we had the funds and all. So we went through that journey, did a lot of relief work for riot victims. So we had gender as well as secularism as our main plank, and we also had a cultural organization, the part which was looked after by my colleague. So then a few lawyers joined us, social workers, support persons, but we set up an all-women team that I was very clear about, that we want to set up this. We will have women lawyers, women court clerks, women staff, everything women. It was very challenging, very difficult. Having women that you're asking for more trouble, because if they get married, they move away, marriage-related migration, they become pregnant, they have small babies, they have to look after their old in-laws or parents. So, and these were all real problems that you could not ignore them. Children have exams, women need to stay at home to help them. And people kept asking me, but why only women? Why only women? Why not men? So I felt that for two things, that women who are in a distress situation, in a conflict situation, they're talking about intimate violence in their lives, whether it is rape or domestic violence, and they would be more comfortable speaking to a woman rather than a male counselor, etc. That was one reason. But there was also another reason, that we wanted to support women lawyers. We wanted to give them confidence. We wanted to give them a role model of feminist lawyering. So that was a two-pronged kind of idea, and we have maintained it till now, that we have only all-women team. And we have moved on despite all these challenges. We also started this district level lawyer training and fellowship of women all over Maharashtra, who after the initial training of 5 days, we would select a few, not those who are best, but who come from like most remote areas. If there is a Dalit, or if there's a Muslim, or if she's only woman in her entire district practicing law, we would identify these kind of people, look at their commitments and all, and select them for a fellowship. During the year, we would support them, and during the year, they would work with other women lawyers and also organize workshops locally so that more lawyers can join in. It was a very good and successful program, but we could not sustain it because everybody wanted to create a mini Majlis in the district, and that would not be feasible from the funding perspective, because you need an office, you need infrastructure, a lot of money, etc. And we could only manage with difficulty the Mumbai office and not in the district. But this lawyer network became very vibrant, and there were a lot of women who understood like rape law, for instance. If you are a criminal lawyer and you're handling rape cases, your senior would only be representing the rapist. So your perspective you would gain is from the senior, where that women are telling lies, women not actually rape, it was consent, etc. All these kind of things. To change that narrative, they would have to work with a public prosecutor, and public prosecutor's permission would be necessary. State permission would be necessary to understand the law from the victim's perspective. How do you provide a support to the victim through a very good lawyering mechanism? So these are domestic violence. That time, Domestic Violence Act had not yet come. It was about to come. And then we immediately did training on Domestic Violence Act, went to Magistrate Court. So that's been a very productive journey of spreading awareness about women's rights, understanding what is feminist lawyering, and evolving feminist legal strategies that could help women. So in this process, we were able to help not only about gender, but also about human rights, about broader issues, what are human rights violations, beyond their scope of just understanding gender, understanding other issues that we are connected with. Like, for instance, now we would be, if we are doing the training, we would take up the farmers issue. Why are farmers struggling? What is it that's happening? Or what is a CAA, struggle against CAA, a Citizenship Amendment Act, contemporary issues, so that they get a wider exposure to all the issues that may come up eventually, and that are contemporary actually, but they're reported in the press, etc. So we realized these lawyers from the districts are very well trained in criminal legal procedure, civil legal procedure, civil legal code, criminal code, etc., and knew all the nitty-gritties of a trial court. But they lacked perspective. So if they had a perspective, they would be far better lawyers in order to help women. And if we taught them feminism, if we taught them what is feminist legal strategy, they what is like 𝗙𝗃𝗃𝗀𝗃𝗃 guidelines, sexual harassment at work, criminal law amendment after Nirbhaya, various things we took on, and during this 5-day workshop, and also help them to, like, how do you face a crowd, public speaking, how do you make a presentation, so that they would go back to their districts and be able to present to a group of lawyers. So these women were very hesitant when they came for the meeting. They would not open the mouth. But after 1 year of fellowship, they had become so confident, and they could speak in public forums, they could work with the prosecutor, they could be part of the legal aid services. So the transformation was just wonderful. They could organize meetings, they would meet the district judge, invite them for addressing their meetings, etc. In the organizing skills, the exposure, all that was great. And the same thing is for the lawyers who have worked with us. They also get this exposure of doing women-oriented litigation. What are the challenges that women bring to you? Again, working with women as victims is also not easy. women keep changing their minds, they don't come back, they have other problems, something else happens to them. So it's not just a linear kind of case. It just goes through all the ups and downs, and through which you keep supporting. So for my team of lawyers, I always tell them, you are here because you have opted for it. You like to do this work. But remember, this is not your life. It is somebody else's life. They've chosen to come to us. But they have also the freedom not to litigate, to backtrack, to withdraw. Just before filing, you withdraw, or after filing, you withdraw. Husband makes certain promises, and this woman goes small pieces, and she says, "No, I don't want to fight. My husband is calling me back." After about 6 months down the line, she's back again. Maybe she's pregnant. She comes back to you, and then you feel like telling her, "I told you so." But how to restrain from doing that, because it is her life. She experimented with it. She had certain hopes. She went back, but now she's come back stronger. That's not a waste. That now she understands court. Now she understands where she stands vis-a-vis her husband, and how do you get orders? How do you implement these orders? How do you remember your dates, for instance? How do you deal with this institution? Small things, which according to me are very empowering. It's not that it's very frustrating to litigate. I think it's very empowering to litigate, because in the process, you learn to deal with an institution. You learn that you and your husband are equal before the law, before the judge, that you are scared, but he is also equally scared. He is no longer the lord and master of his home. He is before the court, and under court, the judge will treat both of them equally. And if there is an order passed in your favor, he cannot violate that order. Otherwise, there'll be a next step, execution steps, etc. So that was very liberating for this woman to find a strong lawyer who the judge respects and who is able to get immediate orders of protection, etc., or stop the sale of a matrimonial home, all of that. And even for our junior lawyers, this experience is very exhilarating, that I went to court and I got this order. Like, I've just been here for a month, and then I've drafted this petition, I've filed it, I was able to argue and get this order, because these opportunities are not given to junior lawyers, particularly women lawyers in mainstream commercial legal firms. So they really appreciated that. And yeah, they leave after getting sufficient experience. They want to set up on their own. But I still feel that the training that they have got, the perspective they have got, continues to go with them. It's not a waste. And today we have in cities like Mumbai, Hyderabad, Cochin, Bangalore, Delhi, a lot of women who have been trained in similar organizations and have brought a transformation in litigation in trial courts, have helped to change the judicial attitudes towards women. Not perfect, but I think we are on the way. Also speaking at judicial academies, at Bhopal or the state academies, again, you meet like a group of 50 lawyers, some 60 lawyers, judges, and you speak to them about law. That is a your individual judge. You go and you bow and you say, your honor, your this, my lord, and all that. And there, if there's a high court judge who's come as a panelist, he and you are equal in that sense. Not the judges believe so, but at least we believe that we are on the same planet. And the judges here, you are the teacher. You are taking this class. So the power equation changes here. So all these experiences were great. Yeah, the law reform happened. Every time the law got amended, we had to explain this law. We have to bring it down to the police, bring it down to the trial court judges, so that they follow this law. It's not just there in the statute book. It is there practically used in a courtroom. So after such trainings, now we have in 2011, we started a program called 𝗙𝗲𝗃, that is support to a rape victim to go through the trial. Now, those who know about criminal trial know the hazardous journey that a victim has to walk after filing the FIR, the various stages that goes on till you come to the final trial. And the trial is the final exam. Like there you are first examined, is like a viva, and you're not prepared. Nobody prepares you. What have you written in a FIR? And maybe this was 2 years ago or 3 years ago. Maybe it was not in a language the child is familiar with. It will be written in Maharashtra, it will be written in Marathi, but the child may have come from Andhra Pradesh or Chennai or some South Indian or North Indian state. So even her mother is illiterate, she's illiterate. Even if they have read it out for her, she has not understood exactly. And whether she doesn't know whatever she told the police, she deposed before the police is actually written here or not. But at the same time, when you are giving evidence in court, whatever you say should match very closely to the FIR. Though the facts may be a little different. You cannot now get into an explanation to say, actually, the police recorded wrongly. This is what I said. No, you have to come very close to what is the contents of the FIR so that there is no great discrepancy. And everybody who's deposing about that incident, maybe she, her mother, her sister, some other neighbor, all of them, the story must match with each other. So this is one basic lesson you have to observe. Nobody can contradict each other. So like that, there are a lot of these things. And best is our client is illiterate. Maybe she has not gone to school, or maybe she's gone to school for just first and second standard. And here suddenly you have this formal setting of a courtroom. There is a judge, there is a defense lawyer, there is a prosecutor. She doesn't know who is who and who is for her. So to explain to her that the judge who sits up there is like a principal of a school, and he's for you or she's for you. So your answers have to be addressed to her. Don't let yourself be intimidated by the defense lawyer. If you have not understood, you can ask for explanation. If you're tired, you can ask for water, you can ask to sit down. If you come to a level you cannot depose that day, you can ask for an adjournment. Lots of these things are there in the statute books, but she's not aware. She just starts crying there, collapsing there. Sometimes they faint in the witness box. So how to avoid those kind of situations? Like a lot of women, when they come to describing the incident, they cry, they break down. So I said, nothing, not to be ashamed of. If you're breaking down, if you feel like crying, you cry. That's not an issue. If you want an adjournment, you can definitely ask. But we are there as a support person after the POCSO Act is coming to 2012 when the POCSO Act came. And there is a provision for a support person. So we go and help not as lawyers, not as watching advocates. We don't file our wakalatnama, but we are there with her to be there to understanding law. But at the same time, not working as a lawyer, but just as a support person. And when it comes to public prosecutor, the public prosecutor has no time to read the case law, to see what is relevant here, what are the issues that have come up. So help the public prosecutor with positive case law, which the public prosecutor can submit to the court. So these are all, because of this, your conviction rate will improve a great deal, because the victim knows what to say in the court. Otherwise, she doesn't know what to say in the court. So that, and today we have reached out to more than 1,000 children who have been raped. So, and we get a conviction rate of about 65-70% as the national and state average is around 25. So that's a huge measure of the success of this program. So now there are, of course, a lot of cases, but there are a few groups who are also trying this measure to see how it works, etc. But you have to be a lawyer or a good understanding of legal mechanisms. You can't just go there and that's, I'm social worker, I'm here to support. You have to understand the nitty-gritties of court. What is possible, what is not possible. You might remember a few months ago, there was a support person and who got the magistrate gave orders to arrest them because he was telling something and they were not listening. And something is the support person can't be inside the court or something, and she violated it, and she answered the court judge, and the judge immediately said, arrest her, put her in custody. You have to understand what is the right line you can't cross, where you can cross and where you cannot cross. So these are very simple, practical issues that come up, and you are there to help the victim. That you must always remember, not to make your point, not to prove your point, not to do some like feminism within the courtroom. You are here because she needs you, and that is the structure, very well defined structure, and you have to fit into this structure, and then try to change that structure. Try to push the boundaries of this structure. You can't say I'm going to do something very radical, and the magistrate will support him, because magistrate is supreme in his court. Whatever he says, he may be a lowly magistrate, not a high court judge or a Supreme Court judge, but when he says arrest this person and put them behind bars, that will be obeyed. So why do you want to like pick up wrong battles to fight? You have to fight the right battles so that you move ahead and not like get stuck on the way. So these are some of the lessons we have learned. When we first started this project, we didn't know anything about criminal courts. Our work was mainly in the family courts, in divorce litigation, in family law, maintenance, custody, protection orders, etc. But in 2011, we started this project precisely because a 4-year-old child had been raped by the watchman of the school very close to the vicinity of our office. And that time we tried to find out, is there anybody doing this work of supporting the victim? And we realized there was nobody. So we said that then we have no choice but to step in. And my team was very hesitant at first, because they felt that we have never done criminal court, we have never understood criminal law to the extent that we understand the civil law. So, but I said, we are lawyers and we must learn. If we do not know, we read up, we make our mistakes, we grow, and we will learn. And it may take some months or a year, but at the end of it, we will be as good as any other. And what we don't understand, we can ask seniors in the criminal law, how does this work? Why does this work in this manner? So, and there is no shame in asking seniors about what we don't understand. Even I ask if I don't understand something. So that's how we have progressed and proceeded. And that is what is, according to me, feminist legal practice. So I'm very happy that we've been able to do this. So
that was great. I think you covered the practical aspects so well, ma'am, that we faced during the trial, and how do you go about counseling the victim who is the complainant, and how crucial it is that it matches and there's no discrepancy in the witness testimonies. Ma'am, the next question would be, what is your opinion on the personal laws? You have also worked on reforming the personal laws. So how do you think we have progressed in that regard? And what do you think about UCC?
Actually, I have written a book in 2 volumes called Family Law, which has a lot of case law, which has very practical clues about what should be done, what should not be done. And my experience is that never mind which personal law you follow, you have the same rights across all religions. There's nothing great going to happen if there's a uniform civil code, or there is no great harm that is being caused to any woman following any religion. Because what women want is that they want protection. Now, what is interesting is Domestic Violence Act, which applies to women of every community, is uniform for everyone. For instance, you have a right of maintenance there, you have a right of matrimonial home and a protection order there, you have a compensation for a disability or harm caused through violence, you have a provision for custody of children, you have every possible right here. And when this act unfolds, and it unfolds in the magistrate court, and this act can borrow the principles from Hindu law or Muslim law or Christian law into the Domestic Violence Act and apply to any woman. That is there. There is absolutely, now this uniform civil code is just, it's an empty bogey that is hanging over everybody's head, but actually it has no substance at all. What do the personal laws explain? They said what is the valid system, valid procedure for a Hindu law, what is a valid procedure for marriage for Hindu law and the Special Marriage Act, Muslim law or Christian law, etc. And of course, tribal communities have their own procedures. When a woman comes to us, first we ask her, what is it that she's seeking? Rather than dwelling over what has happened in the past, which is not very different for a woman of any religion, whether she's a Muslim or she's a Hindu or she's Christian, she is a victim of domestic violence, she's getting beaten, she's getting abused, there is a harassment from her mother-in-law. These are the similar factors. They don't change as per religion at all. She's been thrown out of the house, her children are snatched away from her. So if she doesn't want to divorce, then you apply under the Domestic Violence Act. And everybody gets a similar kind of remedies. There is no difference. And surprisingly, nobody objected to the Domestic Violence Act at all. That Hindus cannot come under it, or Muslims cannot come under it, or Christians cannot come under it, because it was not breaking the marriage, it was not violating any other principle. It was just giving security to the woman, protection to the woman, her right to stay in the matrimonial home. Now, no law or scripture says you must beat your wife. So you have a law that is coming to effect that you should not beat your wife. So people say, okay, 2005 Act gave us the right not to be beaten. I said, excuse me, the right was always there. It is there in the Constitution, Article 21, right to life and liberty. And everyone is supposed to respect it and safeguard your right to live. It's a basic right. But assault as a crime is also there in the IPC, which came in 1860. Which says that nobody can beat anybody, including your own wife. But there's a misconception that husband had liberty, husband was at liberty to beat his own wife, chastise her, etc., etc. Which Manu says this, or some other scripture says this, or Muslim law says this, or Christian law says this. But that is a husband's power as a superior person. As a parent, you have a right to chastise. As a husband, you had a right of chastising. That is like a Mosaic law, that is ancient law, that is Manu's law. But you have a Hindu code bill, a Hindu law that came in 1950s, and it says that under these circumstances where you have a ground for divorce, and cruelty is a ground for everybody. Similarly under Christian law, similarly under Parsi law, similarly under Muslim law. Cruelty is a ground for divorce for everybody. And today, if you see as a lawyer, rather than desertion or adultery, it is more simple and straightforward to invoke the ground of cruelty, because every single act causes cruelty to the woman. Like he's having an adultery that has caused a cruelty. He has deserted her, that has caused a cruelty. He's thrown her out of the matrimonial home, that has caused a cruelty. So the cruelty interpretation is very, very broad. So rather than going under like 13 grounds, 15 grounds, I mean, only as a law student, you have to memorize this. But after that, you don't know, like there's only one ground for everybody. Basically 3, adultery, desertion, and cruelty. But make it even more simpler, the cruelty, you take up the ground and cover everything else. So what will your UCC give you in addition? They say Muslim polygamy. But there is Hindu polygamy rampant. And if you compare Muslim law and Hindu law, a Muslim wife in a polygamous relationship has a right of maintenance, a right of residence. Whereas a Hindu law, Hindu wife in a polygamous marriage is referred to as a concubine, as a mistress. What rights she had earlier under the uncodified Hindu law has been taken out. So now only one wife is entitled. The other wife is not entitled. Now we have cases like where a man has got married in his village, then he's come to the city, then he's got married again, and this husband and wife are living together. Then in my case, he got AIDS, then he died. This woman took a huge loan for his medication to make him comfortable, etc. After he died, suddenly one woman comes from the village and says, I'm the first wife. I am entitled to the end of service benefits, provident fund, etc., etc. Because I'm the real wife. She's not the wife. But she says, I've lived with this man for 17, 18 years. I have 2 children. I have taken this huge loan to buy this better place. And where were you when he was sick to look after him? You never came that time. You never claimed that you were his wife. And I've done everything. So now the judges are confronted with this very complex situation. What is justice? What is law and what is justice? How do you do justice to the second wife, where she has no claim under the law? And of course, the first wife is also wronged. He has deserted her. The second wife is also wronged. He has cheated her. But the man is not living now. He is dead and gone. So how do you do justice? It's so complicated situation. So these are the situations. In Muslim law, we will not have this at all. So people think this polygamy is a big issue. According to me, by making Muslim marriages monogamous, whereas culturally there is an acceptance of polygamy in the villages, among the Hindus, among so many castes, and then you accept this cultural traditions. But when you go to court, you are bound by law, and there is such a big disparity between customs and traditions which are also accepted, and then what the law gives you. And we make these laws without understanding culture and tradition. We make the laws from above, they don't come from below. And the communities, after about like 60 years of Hindu code bill, they are not aware. Nobody told them. Only when you ask for rights like maintenance, you go to court, then you are aware. Otherwise, panchayat system is there, divorce, sorchitis, so many different practices are there where you don't go to court at all. You don't register your marriage, you don't go to court, you can get married, you can get divorced, you can get remarried. There are different different rituals for the first marriage, but there are different rituals for the second marriage, for a non-virgin bride, and you have to prove only 𝗙𝗲𝘃𝗃, and there is no 𝗙𝗲𝘃𝗃 in the second marriage. So you cannot prove there is a second marriage. So you can see the harm caused to women by well-meaning legal experts, because you're not aware of the ground situation. And today, we as feminist lawyers have to cope with this. In a way it was never envisaged. That is why Domestic Violence Act is good, because it does not go into the terrain at all. It just says there's no divorce, there's nothing. You can't beat your wife. You can't treat your wife with cruelty. You throw your wife and from the matrimonial home. This is precisely what the woman wants. She doesn't want anything more than that. Whichever community she belongs to, whichever religion she belongs to. So I feel the rights are there. And only these politicians and this communal politics makes UCC a huge issue. Whereas if you're a lawyer practicing in the court, you have enough legal handles, you have enough provisions in different laws, which will give the woman the right she wants. Custody of children, that's another thing. A Muslim, under Muslim law, a man is entitled to the custody of his son above 7 years and his daughter about 13 years. This is what generally is believed. But there's only one principle in law under the Guardians and Wards Act, which says that best interest of the child. Whether it is in Pakistan, whether it is in Bangladesh, whether it is in India, everywhere what prevails is not Sunni law or Shia law. It is best interest of the child. So if a woman has been divorced and she has brought up a child, and a child is today 14 years old, it is not that a husband can just pick up the child and bring and deprive the woman of the custody, because welfare of the child does not lie in disturbing custody. The child is familiar, her husband has never bothered about the child, the child is settled here, child is educated here, child is well looked after. Why would the court disturb that custody just because Muslim law says this? So we have principles that are evolved, which are beyond personal laws, which are coming under a common principle, common legal domain, which doesn't look at where you're coming from at all. So understanding this is very important. Journalists do not understand it. Politicians do not understand it. They do not want to understand it. Like, for instance, triple talaq. Triple talaq was invalidated in 2002 by a judgment called 𝗙𝗲𝘃𝗶𝗰𝗲. Before that, in 1981, Assam High Court in two particular cases had said that there's a procedure for divorce, and only if you follow this procedure, your divorce is valid. That triple talaq case that you said, Mr. Salman Khurshed. So, according to me, this whole litigation was waste at all. Everybody's time was wasted. At the end of it, what did you get? You get what was in consent is one line. Triple talaq is invalid. But that's it. Which was held before. So what you got nothing except to make a huge political story, anti-Muslim political story, and nothing else. And I was like so amused. I remember, like, at one point of time, there was a big argument about whether interreligious marriages can be performed under special marriage. And some said no, some said yes, but should I have to relinquish my religion? And Salman Khurshed stood up and he said, I am married a Christian woman under the Special Marriage Act. What are we debating about it now? I said that all the 5 judges and most of these lawyers were not aware of something which even a small trial court lawyer knows very well, that if it is interreligious marriage, you marry under Special Marriage Act. I was highly amused at the level of these people who are deciding family law. They are deciding a principle of triple talaq of a particular community. We're not aware of something so basic. So according to me, what justice could they do? I was in court not so much for arguing, but understanding how they function, what is the understanding of law. I couldn't just believe it. And it went on till Mr. Salman Khurshed stood up and said, it is there. I married my wife under a secular law. I am married under Muslim law also, something else also, Christian law also, but I have married under Special Marriage Act, which gives you the privilege of interreligious marriages, validation of interreligious marriages. So that's what we're saying, that is a security. You marry under Special Marriage Act. And that it could cause so much discussion and debate among legal experts. I said, they may know constitutional law, but they don't know personal law. I came to the conclusion.
I think, ma'am, you made a very important point here, that there are principles beyond personal laws that are governing the area of family law that we all need to appreciate, understand, and emphasize upon, rather than getting into the political gimmick that's been happening.
Ma'am, have a look at my family law book, which is like used as a textbook for students in law colleges. It's in 2 volumes and quite detailed. Actually, it deals with all personal laws and also the UCC debate.
Right, ma'am. We have an attendee here, Swapnil, who has also read it. So I'm sure many people follow your book as a textbook, I'm sure. Ma'am, my next question would be, you were talking about conventional solutions vis-a-vis innovative legal solutions. So sometimes what happens, clients come to us and they say, oh, so-and-so lawyer has said case kar do. But when I hear it, I feel like it's a gray area and maybe the client should go back and think on these aspects and then come back. You've also talking about autonomy, respecting autonomy of the client. So sometimes it's difficult to kind of understand where to draw the line between autonomy and respecting the autonomy and advising the client to consider a certain option. So I would like you to explain a bit that.
According to me, when a client comes to you with problems, first thing is they like to speak about the problem and not about the solution. They go back and say every small detail, this happened to me, that happened to me, that happened to me. According to me, in legal counseling, you are not a traditional counselor giving your shoulder for her to cry on. You are there as a lawyer to show her the next step, the possibility. So you may give some time, like set a limit, like 10 minutes or 15 minutes to for her to air out her feelings, but then you should quickly come to, okay, now what do you want? You told me this story. No, madam, I'm not finished. But he said, that doesn't matter. I know this story will go, when we draft, we'll go back to this. But why have you come here? What is the solution you are looking for? And usually they reply, I don't know. You suggest. Okay, then you suggest, like, do you want a divorce? Do you want to stay separately? Do you want to stay within the same marriage? You suggest what best suits you. And make her think. She then not thought about it. Yeah, but this is your life. You want to do something. That's why you come here. So you think, because I've told you, this is the option, this is the option, this is the option. So you think about it and say what best solution you want. So this, I want to change my husband. I want to reform my husband. I said, that's not possible. What the husband has to do, like, I can't help that. You tell me that this is your husband, this is what he does, this is your mother-in-law, this is the home. Into this situation, what possibility are you looking at? Are you looking at a divorce? Are you looking at various options here there? Think about it and come back. Say what is best for you. Do not give a solution on the first day itself. You just explain. And she comes back and she said, this is what I want. Please be fully aware that she may change her mind. Because all of us change our mind about our career options, where we want to be, what we want to do. So she also has a similar right. But you take this, okay, now she wants this. Explain all the pros and cons of that process. That, okay, this is what we can do. This is what is possible. This is what you may rightfully expect. This you cannot expect. It will not happen. Explain the scenario to her. And then you move to the drafting stage, get down the facts, draft. Every time show her the draft. She says, no, you finalize. You say, no, because these facts are your life. What I have understood is what you told me. But you must check it out. You can't just sign on the dotted lines, because tomorrow we'll say in the court, why have you put this? No, my lawyer put it. I didn't read it. I just signed it. She told me to sign and I signed it. As if it's in my interest to get a divorce. So she must take full onus. She must take full responsibility. You say, you think about it for a day. You think about it for 2 days. Nowadays, we can send it by email, etc. Read it, discuss it, whatever. Some facts you're not comfortable with, will change that. You tell exactly what you're comfortable with. Because this is because what does she say? She says, I was married off by my father, then something else happened by my husband or my mother-in-law. It was always in a passive tense. And now you tell me. I said, no, all this time it happened, but now you've consciously taken a decision to come to us, to discuss your case. So this is your case. This is not my case at all. So you tell me, how far you want to go? We can go. If you do not want to go, we need not go. But you have to be comfortable. And this is a very rigorous procedure. So once we make up our mind and we put in writing and we file in court, it's a very serious business. So it will be there in the court record, even if you want to tomorrow withdraw it or whatever, these facts are there and they're said on oath. So you cannot like easily get away from them. In the next, some other litigation, the husband may use this petition, say he or she has said this. So you have to be fully responsible to say what you're saying. And then you move in the court, then you do whatever you can, and you may get an order, and he may not pay, you take an executive proceedings, etc. At some level, she will say, my husband is calling me back, I want to go and stay with him. So you cannot say, no, 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 you can't go. It's her life, it's her husband, her marriage. So, okay, we'll do what is necessary. But they do worse things. They don't tell you, but they feel bad. They quietly go, husband and wife, and they withdraw the case in the court. And it comes as a shock to you, as a betrayal to you. Even that you must accept that it may happen. But all you can do is keep your doors open, that if she needs help, we are there for you. And find out from her whether everything is okay with you, everything is proceeding smoothly, and he's treating you well. But if he's not treating you well, you know where's the police station to file a case, you know where is our office, how to call us, how to get in touch. There is no shame in retracting, it is normal. And leave it there, and after some time she'll come back, because this marriage is not going to, this reconciliation is not going to last for a long time. And the most tragic of them is when they go back and they commit suicide. That is very difficult to accept. That is when you say, we told her not to go, we told her not to go. But it's natural process. So, and if you're a young lawyer, this is your first case, your second case, you're very emotionally attached to it. But even then, you have to accept it, that you're not God. She did what is best for her. So you cannot hold yourself guilty that why I did not do. But because it is not your life at all. You're not a savior. You are only a facilitator for her decision. So this is a very important lesson for us to learn as young lawyers, junior lawyers. You are here because you want to be. This is your choice. So you cannot say, oh, she let me down, she betrayed me, etc. But it is her life. For heaven's sake, don't think this is your life. You take your decisions in your life. Let her take decisions in her life, good or bad. Many times we make bad decisions in our life. Just because she's a victim, she will always take a right decision. No, not possible. So once you've accepted, then it's good.
I think keeping the door open is also a very important aspect.
Very important, yeah.
I have also done that. I have withdrawn a case on behalf of my clients, and it just breaks your heart. You explain it to them, they don't agree, and then you withdraw. But after that, if you don't leave the door open for them to come back, they might find it embarrassing to come back to you again. And they may be dealing with the same thing again and again and again, just because you didn't say that one line at the end that you can come back to me again.
And periodically call her and say, how are you? How are you doing? How are the things with you? Come and meet us just as a friend. Okay. Like that.
Right. Ma'am, there's a question here. Me and my mother are being starved by my father since a long time. He deliberately does not provide us food, medical treatment, and other basic necessities. But since the courts are shut, we can't do anything. Is there any way we can claim maintenance even if the courts are closed and stay without fear of any incident of domestic violence in future at my mother's matrimonial house by my father?
I didn't hear it fully. Can you just say?
So basically, he and his mother
are being starved. Yeah.
Yeah, they're being starved. So is there any way
to? Courts are closed. Yeah.
So any way to claim maintenance and to protect themselves from fear of any incident of domestic violence?
You can go and complain to the police, local police, and the local police can call the husband, father. Here also the police were also closed during the 2 months of lockdown. They had barricaded the police station. Nobody could enter.
And she's saying police is not doing anything. She has already approached the police. Police does nothing.
Go to the higher officer. Firstly, the officer in charge of that police station, if he doesn't go to the DCP of the area. And if the DCP doesn't listen, go to the commissioner, write a formal complaint, go there with a complaint and say that this is not happening in my thing, my life is in danger, I am facing extreme difficulty. It is, and the commissioner is, at evening 1 hour, they keep it open for people to come in any situation. So you have to take it at a higher end. And then if you have media contacts, then you have this story published in a newspaper bulletin, something like that, or circulated, etc. I agree with you, the lockdown period was very difficult because you could not go to court, you could not enforce maintenance orders, and the husbands took full advantage of that. So it is very important for the woman to take action, go and stay somewhere, and also the police can provide a safe shelter. If this is the situation, it's a dire situation, and they don't have food to eat, etc. Rather than suffering there, you could ask for shifting of very well-maintained shelter home in your area, and tell the police that I need to be taken there, and providing this, that because under the DB Act, they're supposed to do this. A protection officer or a police are supposed to provide a shelter for the woman, a safety mechanism, the mother and the child, both. Yeah.
If you could tell us where are you based at, then perhaps
I'm in Mumbai.
I'm asking the anonymous attendee here.
Okay.
So that yes, because in Delhi, etc., I think it's possible right now to get a DV order. So I really
where are you situated? That's very important.
Delhi. So I think in Delhi, online virtual hearings are possible. So you should contact a lawyer and get a order under the DV Act. It's possible.
Online are available only in High Court and Supreme Court.
Ma'am, in trial courts in Delhi, we are doing online virtual hearings. Even divorce matters, etc., are being heard on.
Family court is doing virtual?
Yes, ma'am.
Family court is doing virtual. Yeah, now we have just in Bombay started filing.
Even other courts, ma'am, bail matters, etc., in trial courts are being heard virtually.
Okay.
So I think you can do that. You can get an order under the Domestic Violence Act. Please contact the lawyer.
Yeah.
Ma'am, there's another question. Could you talk about what rights a woman has in an intimate relationship other than marriage? Yeah. How can we approach the law in cases we are in a live-in relationship or in an emotionally and physically abusive relationship?
Here, actually, Domestic Violence Act provides you that long-term relationship where the couple has lived like a husband and wife, they have projected to the outside world as husband and wife, is like marriage, and you have every right to get protection under this. There is one hitch here, whether the person is already married to somebody else and whether there is a right here. Now, there are contradictory judgments here. Justice 𝗙𝗀𝘃𝗀𝗀's judgment, which says, oh, she is only a concubine or a mistress, and she has no rights. Whereas there is a later judgment, I think Justice 𝗙𝗃𝗃's judgment, 𝗚𝗲𝘃𝗀𝗃𝗀 something, which says that he has not disclosed that he was married earlier, and she got married believing that he was single and he had the capacity for marriage. In such a situation, he cannot be allowed to take advantage of his own wrongs, and that woman has rights. Now, then there is one more judgment after this, which has similarly held. This was 2014. Justice 𝗙𝗃𝗃's was, I think, 2011. But I think now the situation is more clear that even if he's married before, this woman in the relationship with him has a right, particularly if he had not taken her consent or not disclosed the earlier marriage, he definitely has a right of maintenance and residence. And as I said, nobody has a right to beat anybody, wife or no wife or stranger or whatever. This is a constitutional guarantee of life and liberty. So the husband cannot say, I have not married her, so I can beat her. I mean, where does this come from? So she can get a protective order against beatings, cruelty, throwing out under the Domestic Violence Act in any situation, according to me.
Yes, ma'am. Ma'am, last question. It's 6:16. We are just concluding here. My last question would be, any last advice to the lawyers? Of course, we have understood and we have learned a lot during the session, but any last piece of advice for lawyers who are working on gender issues?
Firstly, you have to unlearn a lot of things you have learned in law schools, in formal law, etc. Then you have to understand the situation from a woman's perspective. In such a situation, what does a woman do? What you say? Understanding of a common man. Now, there is one very good essay written by Justice 𝗙𝗃𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏 common man perceives, what a common man understands, what a common man believes. But she says we never talk about a common woman, because a common woman does not believe as the same as a common man. So you have to read essays like this, where like we saw in the lockdown situation from the health ministry, they brought in all rules, regulations, etc. for a community. Now they never had the sensibility of a woman, that how will it the same thing affect a woman in a domestic abusive relationship or a children. There are lots of cases of rapes by fathers, domestic violence against wives, lack of courts and other resources available which are there in the normal times, and this is worldwide. Every country has reported this. So, and I said the biggest fault here was, okay, you brought in lockdown, but you never thought that women would suffer in a different way than men do, and you never brought in any regulation. Now they say, that relief for women, centers, shelters, etc., have to be treated as emergency services during a lockdown, and they can't be shut down, or a police access to police stations, etc. They can't be shut down at all. So this knowledge has everybody is awakened to this knowledge now after when they see the situation, but they never thought. And this is true of famine or floods or earthquake or any situation. You think of the whole community, you think of a very generalized situation, you never see how women get affected into this, whether it is food resources, food packets, how women are not able to get what men are able to get, single woman headed households. Each of them have suffered from different kinds of disability, and we need to understand it. So similar, our judges have to be trained to understand a woman's situation. Why does she go back, for instance? Why does she retract? What is the challenges that she has to meet? Why doesn't she leave at a particular time because the children's exams are going on? She can't leave because the children will miss a year. So these are very practical kind of situations. And for us, it is very important to understand and develop that sensibility as what does a common woman perceive, and work from that point and make the judges realize this and try to find case law which contextualize this in particular.
Ma'am, there's another question. Being a girl child, is there any way I can claim share in my father's property in spite of his will?
In spite of his will, no, because he's already made a will. But if he's not made a will, she can.
Right. So under Hindu law, of course, if it's Muslim law, only 1/3 can be given away by way of will. So it depends on which personal law you're being governed with. Madam, what is your perspective on abuse of legal provisions by women, like Section 498A against men to avenge vengeance? So basically, misuse of 498.
Well, this is a very common question that comes every time. We just presume there is a misuse. I'm not saying there is no misuse. Every law is misused. There's nothing unique about this law. But if you compare the number of women who are abused in a domestic relationship to the number of cases actually filed, you will see that there is underuse rather than misuse. Number one. Second point to compare, how many women have died in that area and how many women actually filed cases under 498A, and whether any woman who died has filed under 498A before she died. You will find none. No woman is filed under 498A, number one. And secondly, the number of 498A cases is overall 3 times more or 4 times more. Are we to presume that the woman who died is definite number? Suppose there were 100 women who died, a natural situation. And there are cases, 400 or 350 cases of 498A. How can we say there is misuse? That means only that many women were beaten by their husbands or thrown out of their homes. A large number of women do not file the case at all. Among the few, we start using the law and immediately the misuse bogey comes in the way. For instance, how many husbands commit bigamy? How many husbands have more than one wife? And how many men have misused the law of monogamy under the Hindu Marriage Act? We never talk about it, never talk about it at all. A woman goes to court, there she realizes he's married and she's not the real one, and she is denied maintenance. We never say this man misused the law. There are so many instances the women and children are deserted, thrown out. That, like just now the case that without food, without basic necessities, without shelter, they're thrown out. Now, under marriage law, he is supposed to provide for his wife and children. He is not doing this. Look at the number of single women-headed households. UN statistics, etc., has it. Why we are not saying these men are misusing the law? They promised to look after this woman. They have thrown her out. They have done total disregard for the law and thrown the woman out. Why don't we say there is misuse of law at all? It's only for 498 there is a misuse. For nothing else, there is a misuse. I mean, where are we getting this language actually? This is media creation. This is lawyer creation. Because the same lawyers will gain money by filing for anticipatory bail. Huge amount they will charge for anticipatory bail, because now they say she will file for 498 and you will be arrested. So we need to protect you. They'll find people in the house though. So the anticipatory bail amount will be like, I don't know how much, 10,000, 20,000. Because by this scare, the lawyers mint money. But why anticipatory bail? You get arrested, next day you can file and get released. What's the big deal? All these guys, human rights defenders, are in jail for like 2 years, 3 years, for instance. This one man goes, and his mother or father goes for like 1 or 2 days or 1 week. Why the heaven has not come down? This woman is anyway thrown out when she's pregnant.
Also, there are provisions relating to perjury. There are sufficient safeguards to protect you if a false complaint is filed.
Here is the question: do men have any protection in the DV Act? So I want to explain here. The DV Act is a civil law. There is no arrest under DV Act unless he violates an order. So what kind of protection? And as I said, no law says a man has right to beat his wife or throw her out. No right is there. So whether it is under DV or without DV, men never have this right to beat their wives. So if there is an order come that she cannot beat the wife, how is it misuse? He's never beaten, fine, she's gone to court. But what she says, I want protection. He's threatening to throw me out. He's threatening to throw my children out. So he says, I've never done this, I will not do. The court says, okay, give it in writing and your case is over. So he gives in writing. Where is the misuse? Where is the protection? What is the need? We're not understanding, even if we are lawyers. 498 is a criminal IPC provision. DV is a civil law. Under DV, there is no arrest. So there is no need for any kind of protection.
I think the question could also have been that whether men can claim any relief under the DV Act. because DV Act is not gender neutral to that extent that a man cannot be a victim, even though it can be against in-laws, it can be against in-laws who are women, but the victim, essentially the aggrieved party, has been defined as a woman. So something on why don't we have gender neutral laws?
I'm not the right person to answer that because I'm a women's rights lawyer. I feel women need protection, and that's why this law has come about. There has to be a campaign, how women campaign for a for a domestic violence act. If men campaign and show the instances where this is being done, statistics show it, and do the campaign. Men's rights groups are really trying very hard.
That's right. I think the way the power structure in our society is at the moment, I don't think we need gender neutral law. When we will need, of course, we will have.
Yeah.
Thank you so much, ma'am, for such a wonderful session. We really enjoyed it. I'm very sure all the attendees did. We have had feedbacks where everyone has been very appreciative of your point of view. Thank you so much, ma'am.
Thank you so much. It was
and if anybody wants to have more such webinars on these issues, please feel free to write, because it's very important to keep this narrative alive.
Sure.
There are not many takers, and therefore we focus on certain aspects and we tend to ignore. It's very important to bring it in the narrative and therefore to keep talking about it. Yeah. Thank you so much for joining us. Thank you.
Yeah, there are a lot of comments here appreciating this talk. I'm very happy.
Yes, everyone really liked it. Yeah. Thank you, ma'am. Thank you.
Okay, bye.
Bye.